On February 3rd, the Supreme Court came to 3 decisions. I will read to you one of the decisions as follows. Supreme Court of the United States, Salinas versus United States Railroad Retirement Board. Certiorari to the United States Court of Appeals for the Fifth Circuit. Argued November 2nd, 2020, decided February 3rd, 2021. In 1992, petitioner Manfredo M. Salinas began seeking disability benefits under the Railroad Retirement Act of 1974, RRA, based on serious injuries he suffered during his 15-year career with the Union Pacific Railroad. Salinas's first 3 applications were denied, but he was granted benefits after he filed his 4th application in 2013. He timely sought reconsideration of the amount and start date of his benefits. After reconsideration was denied, he filed an administrative appeal, arguing that his 3rd application, filed in 2006, should be reopened because the U.S. Railroad Retirement Board had not considered certain medical records. An intermediary of the board denied the request to reopen because it was not made within 4 years of the 2006 decision, and the board affirmed 20 CFR 261.2b. Salinas sought review with the Fifth Circuit, but the court dismissed the petition for lack of jurisdiction, holding that federal courts cannot review the board's refusal to reopen a prior benefits determination. Held. The board's refusal to reopen a prior benefits determination is subject to judicial review. A. The RRA makes judicial review available to the same extent that review is available under the Railroad Unemployment Insurance Act, RUIA. See 45 U.S. Code 231G. Thus, to qualify for judicial review, the board's refusal to reopen Salinas's 2006 application must constitute any final decision of the board. 355F. It does. 1. The phrase "any final decision" denotes some kind of terminal event, and similar language in the Administrative Procedure Act has been interpreted to refer to an agency action that both 1. Remarks the consummation of the agency's decision-making process, and 2. Is one by which rights or obligations have been determined, or from which legal consequences will follow. Smith versus Berry Hill, 587 U.S. The board's refusal to reopen Salinas's 2006 denial of benefits satisfies these criteria. First, the decision was the terminal event in the board's administrative review process. After appealing the intermediary's denial of reopening to the board, Salinas's only recourse was to seek judicial review. Second, the features of a reopening decision make it one by which rights or obligations have been determined or from which legal consequences will follow. For example, a reopening is defined as a conscious determination to reconsider an otherwise final decision for purposes of revising that decision, 20 CFR 261.1c. It therefore entails substantive changes that affect benefits and obligations under the RRA. The board reads 355F's earlier reference to any other party aggrieved by a final decision under subsection C to mean that each authorized party may seek review of only a final decision under 355C. Section 355F, however, uses the broad phrase "any final decision" without tying it to the earlier reference to 355C, a notable omission, since Congress used such limiting language elsewhere in 355, see 355C5. 2. Any ambiguity in the meaning of any final decision must be resolved in Salinas's favor under the strong presumption favoring judicial review of administrative action, Mock Mining, LLC versus EEOC 575, US 480-486. The board attempts to rebut that presumption by arguing that various cross-references within 355 prove that 355F and 355C are coextensive. There are several indications, however, that 355F is broader than 355C. For example, under 355G, determinations that certain unexpected funds may be used to pay benefits or refunds are subject to review exclusively under 355F. Yet the board concedes that such decisions fall outside 355C. B. The board's remaining arguments also fall short. First, the board analogizes 355F to the judicial review provision addressed in Califano v. Sanders 430 U.S. 99. But the later provision contains an express limitation that 355F does not distinguish Califano from this case. Second, the board argues that reopening does not qualify for judicial review because it is simply a refusal to make a new determination of rights or liabilities, like the denial of reopening in Your Home Visiting Nurse Services Incorporated versus Shalala 525 U.S. 449. The statute in Your Home, however, did not implicate the presumption in favor of judicial review and was narrower than 231G, which simply incorporates 355F into the RRA. Finally, the fact that the board could decline to offer reopening does not mean that having chosen to provide it, the board may avoid the plain text of 355F. The board's decision to grant or deny reopening is ultimately discretionary, however, and therefore subject to reversal only for abuse of discretion, see 20 CFR 261.11. 765 Federal Appendix 79, reversed and remanded. Justice Sotomayor delivered the opinion of the court in which Chief Justice Roberts, Justice Breyer, Justice Kagan, and Justice Kavanaugh joined. Justice Thomas filed a dissenting opinion in which Justice Alito, Justice Gorsuch, and Justice Barrett joined.